All right, well, that sets the table for the discussion at hand. You know, when it comes to these interfamily relationships, there are different permutations. That was one such from TikTok where a young mother didn't want her parents seeing the kid, but the parents petitioned the court. And I don't know if they had a relationship that was established. There's a lot of fine points in the current law, which is above my purview to understand. So that's why we defer to the experts. In this case, it's Laura Paris, lawyer with Shulman Partners, discussing the rights of grandparents in the province of Ontario. Laura, it's good to have you here on the Oakley Show. Good afternoon.
Hi, John. Thanks for having me.
All right. So just having listened to that clip, if you had a chance, I guess it does cut both ways, or there are several different ways you can understand where grandparents either have rights or they don't have rights, and how they're exercised, or they can be deterred from exercising those rights. Spell it all out for us. What does the law say?
Yeah, so pretty much, I mean, this is when we're talking about anything related to children, access to children, decision-making for children, the threshold is what is in the child's best interest. So within the last couple of years, I believe it was actually in 2000, the Divorce Act and the Children's Law Reform Act were amended. So the Children's Law Reform Act is for specific to Ontario. Divorce Act is federal. So it applies to, any married couple or child of a married couple. And it was amended to give specific rights to other family members, including grandparents, to seek contact or parenting orders. Now, the threshold, again, that is considered is, generally speaking, the best interest of the children, which takes a lot of things into consideration. It takes into consideration, for example, if there was an existing relationship. It takes into consideration what the child's views and preferences are. If there's any safety concerns, anything to that nature. So in order to give, kind of a specific advice, or to kind of understand how this is going to play out in any given situation, it's going to turn on the specific set of facts that are related to that case. So, you mentioned when you were kind of leading up to this after listening to the TikTok, there's a lot of nuances that are not stated within that, 30-second TikTok that would help us better understand why that order was made, giving these parents contact if there was a history of abuse with the mother and her parents. Now, again, in a situation like that, it could be that, they weren't great parents to her, but they're great grandparents. And the child had a relationship with the grandparents, and that's why that order was made. But it is somewhat difficult, just based on the limited information given, to determine exactly why that order was made that way.
Again, with Laura Paris, this has to do with grandparents' rights. And the interesting point that was made, nuance was the word you used, a lot of different iterations of what could take place here, what the family dynamic is. In that case, the TikTok clip that we played, the mother of the children didn't want the grandparents to have any access to her kids. She cited abuse. I mean, that's, something that is subjective, or we don't know. But so the parent alone can't necessarily make the call on behalf of their children.
So it depends, and this is an answer that I give in a lot of context in family law, unfortunately, because it's a very gray area of the law. And when I say that it depends, the leading case on this, which is actually from, I believe, 2001 in Ontario, the Court of Appeal. Actually, it was parents that weren't in a separation. It was two parents that were together, and a grandparent was seeking access to the grandchildren when the parents had specifically rejected their relationship with their parents. And the court decided that the parents were credible people, that they were raising their children in the right way, that they had no reason to doubt that the parents were capable of making a decision that was in their children's best interest. And in that case, they said, unfortunately, no, the grandparents do not get access because we trust that the parents are making the best decision for these children. So what actually ends up happening in a situation like that is the onus is actually going to fall on the grandparent to show that the parent is not capable of making an appropriate decision in this circumstance. And as such, the court needs to interfere and interject on that and kind of go over the parent's head and make a decision for them if they believe it's in the children's best interest to have a relationship with that grandparent.
Yeah, when you say the parent is not capable, this is something, I guess that would be determined by the court. But what if the parent is maliciously cutting the grandparents out? Could the court also suss that out?
Absolutely. And this is where if there's a existing relationship between the grandparent and the child, something like that is going to be heavily weighted in the court's decision with respect to whether or not to allow that parenting time. Because ultimately, one thing that is recognized and specifically within the best interest of the child test is that children benefit from having relationships not only with both of their parents, but also with their extended family. So when a parent specifically makes a decision to limit their child's ability to spend time with someone from their extended family, that kind of brings into question their decision making. And are you making this decision because there's a reason, or is it, again, like you said, just malicious intent? Just you don't like your parents, so you don't want them to have this relationship, but maybe that relationship is actually a great thing for your child. So again, if there is a pre-existing relationship between the grandparents and the child, that's going to make it a lot harder for the parent to be able to push against that, because the child has now already established a bond, and the breaking of that bond could potentially be detrimental to them.
Just a couple of quick questions here. Do young children testify in court to the effect that they do want to see or don't want to see their grandparents?
So it's not, they wouldn't actually be called on to testify in court. We actually have in Ontario the Office of the Children's Lawyer that is actually appointed to act on behalf of the child, to ascertain their views and preferences and put them before the court on the child's behalf. So what you're doing is you're limiting having the children actually in a courtroom setting, which could be obviously very traumatic, and you're doing it in more so in a controlled environment with people who are specifically trained in having these types of conversations with children, ascertaining their views and preferences, making sure that they're not being influenced or any alienation is there or anything like that, and putting forward their views and preferences in that manner on their behalf, rather than having children attend that court.
Laura, are you seeing increasingly that grandparents are maybe petitioning the court or even filing suit to gain access to grandchildren?
I have, and I think that this is actually because of the amendments that we've seen to the Divorce Act and the Children's Law Reform Act. I think that it was prior to, while grandparents were making claims prior to those changes, with the changes specifically spelling out that a grandparent does have the ability to make such a claim, I think it's given people more knowledge to know that this is actually something that you can pursue. Family law has a lot of misconceptions with it, and I think prior to those changes, not many people realized that they would have standing in court as a grandparent to seek access to their grandchild.
Very enlightening. I appreciate you bringing us into the loop to understand the situation with, a family dynamic that could be poisoned in some regards. Thanks so much for your time, Laura.
Of course. Have a great day.
And you, Laura Paris, lawyer with Shulman Partners on the matter of grandparents' rights.